Hello everybody, you're very welcome back to Law Hero. My name is Jen and I make videos about the law. And today we're actually going to talk about AI and intellectual property. This to me is the biggest topic when it comes to AI, because the question is, who actually owns the result of the AI input? I use ChatGPT like everybody else, and it is amazing what it can do, but a lot of the time it's just giving me ideas and I have to edit all the stuff myself. And also when it comes to like using DALL-E, I actually find it quite terrible. I remember a few weeks ago I asked DALL-E to make some covers for me or some artwork, and it was just the worst artwork ever, and I just ended up doing it myself. So yeah, I was like, you can have your IP. I don't really care what you're doing. But yeah, we're going to take this all back to first principles, and we're going to try and learn an awful lot today, myself included, because I am definitely not an expert in this, but I'm trying to become an expert in this as best I can by learning as much as I can. So I'm tired of people speaking about artificial intelligence and not knowing what it is. So what it actually artificial intelligence actually means is a branch of computer science in which computers are designed to perform in ways which mimic human intelligence, namely the ability to perceive, analyze, learn, reason, and deduce. So that's a really good definition. And the other one we often hear about is machine learning. So then the question is, what is machine learning? This involves learning from examples rather than rules designed by a human programmer. Machine learning algorithms allows computer to extract patterns from data, and when the machine learning algorithm is presented with a new item of data it's not seen before, it is able to use a representation it learned during training to make a good prediction associated with the new item of data. And that's kind of what we see from ChatGPT, which is a large language model, or LLM. Not like we do LLM, but an LLM, which is trained on enormous amounts of data and uses deep learning algorithms to process and understand natural language. So the next question is, what kind of law do we have around AI? So as most of you will already know, on the 21st of April 2021, the European Commission published its proposal for the first legal framework on artificial intelligence. So on a quite like a high level, AI systems that lead to a clear threat to safety, livelihood, and or rights of citizens will be deemed an unacceptable risk and accordingly banned. Examples include social scoring by governance and toys using voice assistants that encourage dangerous behaviour by minors. God, did you ever even think that a Molly Dolly would become real? High-risk AI systems will be subject to strict obligations. For example, risk assessment, log activity, detailed documentation on the system, and ensure appropriate human oversight. So the funny thing is with all of this is that I'm starting to see a sort of a pattern in this type of regulation. For example, when crypto first came out, I wrote an article about it because I was quite interested in the reactive nature of regulation and kind of how regulation is always a little bit like lagging behind what the technological capabilities are. And I find it pretty much the same with this AI regulation. It's very much reactive, and I'm sure toys telling kids what to do will actually be the least of the worries that we're going to have the world over when it comes to AI, but I just still think it's interesting that that's what they're doing. And this kind of oversight piece, it's putting the obligation on the person who's operating it, and that's actually where the liability will start as well. But anyway, today what we're very worried about is the IP, or the intellectual property, and the impact that artificial intelligence is going to have on intellectual property. Because when you think of intellectual property, you think about concepts like who's the author, originality, and whether those laws are actually capable of being applied to AI systems and technology. So remember earlier we said that AI learns from training data through machine-based learning. Well, this means then that if we're training AI, who owns the underlying data? And is it even protected? So this is like copyright protection for the training data and including source code, sui generis and copyright database rights to protect the underlying training data, patent protection for training algorithms as mathematical method exceptions, and protection of the algorithms and training data as trade secrets. So those are 4 ways in which IP can potentially be protected. So if we look at the definition under the Irish Act, it says, in the case of a literary, dramatic, musical or artistic work which is computer generated, the author should be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. So the necessary arrangements, by that definition, is the person who inputs. That would be my understanding. And some of you may have heard the recent January 2023 lawsuit between Getty Images suing Stability AI for unlawful copying and processing of millions of copyright protected images and the associated metadata from its site to train the Stability AI software. This is the first major IP dispute in the UK concerning AI that has been trained on unlicensed creative works. So the other thing around training data is that there's actually a text and data mining exception under the Directive on Copyright in the Digital Single Market, or the DSM Copyright Directive, for text and data mining, which we call TDM. And this is a form of AI technology used to train AI, and it's defined as any automated analytical technique aimed at analyzing text and data in the digital form to generate information which includes but not limited to patterns, trends and correlations. The 2 exceptions are lawfully accessible and are under Article 3, TDM for scientific research, and Article 4, TDM for any purpose provided the rights have not been opted out, which is stated in the Copyright Directive as expressly reserved by the right holders in appropriate manner, such as machine readable means in the case of content made public available online. As we said earlier, when it comes to database rights as an input for training data, there's usually 2 types, which I mentioned earlier as sui generis database protection under the database directive, which protects data structured in a database regardless of originality and where there is a substantial investment in obtaining, verifying or presenting the contents, and copyright protection for databases as literary works, for the structure of databases and the selection of arrangement of their contents. When it comes to copyright in the training algorithm, even if the implementation of the algorithm in software or computer programs may benefit from copyright protection, there may be valuable ideas behind or incorporated into the algorithm capable of being analysed, meaning that relying solely on copyright protection may be sufficient. And I agree with that. Then the other area which I mentioned is patents for training algorithms as mathematical methods with a technical effect, and they will be registered in the EPO under Article 52, which states, this is under the European Patent Convention, computer programs and mathematical methods per se are in principle excluded from patentability. There is an exceptional for mathematical methods of a technical nature. So that's how you would register those. And then the final way to protect what you're inputting into an AI system would be as a trade secret. So in the EU, we have a trade secret directive, which is 2016. And that gave harmonized definition of a trade secret as requiring that the information is secret, has commercial value as a result of being secret, and that reasonable steps have been taken to keep it secret by any natural or legal person lawfully controlling the information. So it's under the kind of reasonable steps that you would take positive action to keep the training data and training algorithms sufficiently confidential via safeguarding mechanisms. Now, let's move towards who is the author or who is the inventor problem. So the problem is, because AI can produce works that are original and inventive, as we all know, should IP rights also be conferred on the AI itself? So the first one comes down to copyright. As we know, only works created by a human are capable of being copyrighted, at least in most countries. Here, under our Act, we protect computer-generated work which does not have a human creator. Now, interesting, because this is such a lively debate worldwide, there was a 2019 AI-PPI World Conference, and the adopted resolution was that AI-generated works should only be eligible for protection by copyright if there is human intervention in the creation of the work, and provided that the other conditions for protection are met. AI-generated works should not be protected by copyright without human intervention. With patents, there is also a difficulty in identifying an inventor who would be solely an AI-created invention. Inventing is seen as a human endeavour under Article 60 of the EPC. And indeed, this hasn't been tested in Ireland, but in the UK, in some cases, one called Dabus, it was held on Court of Appeal in September 2021 that an AI machine does not qualify as an inventor under the Patents Act 1977. The final piece I want to discuss is IP issues to consider if you're using third-party AI, which is what most lawyers want to know about. So given everything we discussed, the question is, are your ideas being inputted into an AI, and then who owns the output? And there's a natural tension here because, of course, the licensor doesn't want to lose proprietary control of its AI asset, while me, as the buyer or licensee, I want recognition of the value of the input that I have put into the training data, and I don't want to be bound by the licensor indefinitely. So I think definitely from my perspective, the best strategy is to look at the output, see why the output, especially when it comes to deep fakes, is important, because in that case it doesn't matter that the underlying data isn't owned legally by the person whom the picture is about. It's about the output, I personally think. So yeah, I think that's an interesting aspect to look at, is the whole IP area. For me, I think going forward, I think there definitely needs to be legislation, and it definitely needs to be output based, because the AI is able to scrape the internet, use public information, adapt it, and whatever the output could be, that could be very, very damaging to whomever the underlying information is about. And I think the only way to control AI is through human intervention. So yeah, that's a quick look down through the IP issues that come up with AI. The next video we're going to look at is AI and tort law.